My name is Meg Garvin. I am the executive director here at the National Crime Victim Law Institute in Portland, Oregon, and I have the great privilege of speaking with Senator Jon Kyl from Arizona today as we start to honor the 20th anniversary of the Federal Crime Victims' Rights Act. So, Senator, before I even ask you the first question, just thank you for being here with us today. It is just a deep honor.
Well, thank you very much. It's a pleasure to be with you and to remember some of the folks who really helped us get all of this done.
Can you tell us a little bit about what the difference is and why you were aiming for a constitutional amendment?
Most of the prosecutions of crimes in this country occur at the local level, in county courts, because of violations of state statutes. We were proposing was a federal constitutional amendment so that all crime victims, whether prosecuted in state courts or in federal court, would be protected by rights similar to those that the defendants are protected by in the Constitution. So that you'd have right next to each other the defendant's rights, like the right not to testify against yourself and the right to remain silent and all that. That's the accused rights, and right next to that would be the victim's rights. And what we were ultimately able to do was not to be able to pass the constitutional amendment, but rather to pass a federal statute that pertained to all prosecutions of federal crimes in federal courts. So having a federal statute with all of these victims' rights articulated helps to let everybody know this is what's important to do in the future. And when states are talking about passing their own or their own state constitutional amendments or statutes, they have a template they can look to tell them these are the important rights. This is what was done at the federal level, and we should try to emulate that as much as we can.
April 22nd, 2004 is when the U.S. Senate approved Senate Bill 2329, which is the Scott Campbell, Stephanie Roper, Wendy Preston, Luarna Gillis, and Nyla Lynn Crime Victims' Rights Act. And it passed with a vote of 96-1, which is amazing. And that bill afforded crime victims clear rights. You were a lead sponsor on that, and that is why we're celebrating, why we're talking with you. Can you tell us a little bit more, because you've already started to tell us, about why rights were important to pass into law in the first place?
So I actually got involved in this long before I was involved in politics. I was on the Maricopa, in fact, I was chair of the Maricopa County Crime Victim Foundation. Now, this foundation helped to administer the funds to crime victims that were appropriate under our statutes at the time. When I saw some of the stories of people who were victims of crime, and money doesn't solve all of these problems. We were able to dispense some funds to help them, and that helped, but it really didn't deal with all of the things that the victims had to deal with. When I got into the House of Representatives, we did several things. First of all, we passed a law that actually limited the ability of sex offenders to suppress evidence of their prior sex crimes in court. They couldn't suppress them. In other words, the defendants were able to get that information out to the jury. We also worked to integrate victims' rights into the federal rules of criminal procedure, which is a very important way for the victims to be able to get the court to consider their rights. So there were other things that we tried to do. But when I got to the Senate, with the help of Steve Twist, who really convinced me that, and he was absolutely right, without a federal constitutional amendment, all of these other things helped. They were important, but they weren't the ultimate answer. And so we, working with Senator Dianne Feinstein from California, we began work writing the federal constitutional amendment and trying to work for its passage.
Was it challenging to work across the aisle on this, or is there something about victims' rights that can and maybe should bring people together?
Well, I had talked to Dianne enough to know that she was concerned. She was a woman of great compassion. She had compassion for these victims. And so I thought, well, she's the perfect partner on this. And if you're going to get anything important done in the US Senate, you've got to have both Democrats and Republicans working together, because the first thing is you have to get over 60 vote threshold. And of course, for a constitutional amendment, it's even more than that. When you're talking about amending the US Constitution, you really need to get it exactly right. So we talked to important law professors, Professor Lawrence Tribe from Harvard, for example, and others who helped us realize how we could draft the language in a way that fit into the constitutional rubric, was pretty parallel with the accused rights. So the two kind of stood side by side, and were rights that could be enforced in both federal and state courts. And we were able to develop that language and get it before the Judiciary Committee. Both of us served on the Senate Judiciary Committee, and we actually got hearings and were able to try to move it forward in the Judiciary Committee of the U.S. Senate.
And one of the rights that you all put into the language is this eighth right. It was listed in an order, and I love this language, so I'm going to quote it. And I'm sure you know it, but just for our audience, the eighth right is the right for victims to, quote, be treated with fairness and with respect for their dignity and privacy. It's this wonderfully broad language and a broad right. Can you share what you were intending to achieve with that right and why you thought it was important to have in there?
Where if you have had any experience dealing with the victims of crime, particularly serious crime, and particularly crimes of sexual assault and sexual abuse, you immediately see the damage that has been done to the victim, robbing that person of personal dignity and power over their own body and their own life. And when you have the trial and the court proceedings reenact this all again, and that's essentially what happens in the trial, it's very easy for the victim to be, in effect, victimized a second time. Before it ever starts, we want the trial with the judge in command here to say, now, we have an obligation, in addition to get to the bottom of this and to give the accused a fair trial, to protect the dignity of the accused, who, after all, is now suffering a second time, regardless of whether the accused is the person that did it. This person needs to be, the victim needs to be protected in her own humanness, and we need to protect her dignity.
So there's something else unique in the bill, and that became the Crime Victims' Rights Act and got passed into law, and that is real clarity that the rights belong to the victim, that a victim can independently ask for the rights in trial courts. They can seek appellate review if a right is denied. And this idea that rights really belong to the victim was groundbreaking. So can you share a little bit about why it was important that that was included?
Some states where the right was deemed to be enforceable only by the prosecuting attorney, like the county attorney, and there was no independent right of the victim to, by herself or himself, bring something to the attention of the judge. For example, I want to talk at the time of sentencing. I was the victim of the crime. Well, the prosecuting attorney doesn't think that's important, or just for one reason or another, doesn't want to raise that right on my behalf. I should have the right to ask the judge myself. I have standing to bring it before you. And so if I'm represented by a lawyer in court, that lawyer can bring it forth on my behalf, or I myself, pro per, can say, Judge, I know my rights here. I have the right to talk, to tell you something, or to tell the jury something during the time of sentencing. So when you get ready to do that, call on me. That's my right. It's the idea that there is no real right without a remedy. And if you have to rely on somebody else to raise that right for you, that's not really your remedy. You have to have the right yourself to bring it up. And that's why we thought that was important.
It has been 20 years since the Senate passed the bill, and then this coming October, it'll be 20 years since it actually became law. The House passed it, it was signed into law. Right. So as you reflect on it, do you believe we've achieved the vision you had when you were crafting this law, or is there work that you think is still to be done?
Well, there's work yet to be done, but we've accomplished a lot. First of all, it took a while for for this to gel and for courts to become aware that, that it existed. So it took good lawyers like yourself and Steve Twist and others who knew about it and were ready to bring it to the attention of courts. In 1996, the Ninth Circuit Court of Appeals, in a case called McKenna, really institutionalized this by giving Mr. McKenna the right to speak to the jury, for example. And courts and judges and other lawyers, when they read this case, began to realize, wait a minute, we got to go to the statutes and look this up. This is important stuff. And since then, we made great progress in courts all around, federal courts all around the country. But again, I emphasize federal courts. Now, there about 2/3 of the states have either a state constitutional amendment or state laws similar. So with both state courts applying the laws there and the federal courts applying the law, you began to get a body of law developed. And that's important here because as each of these situations arise, now the courts can go to the case books and they can see what other courts have done in these situations and interpret the law. There's still some things that need to be done here. For example, we believed when we drafted this that the rights of the victim attach immediately upon the commission of the crime. A woman is raped immediately. The people in charge of collecting that evidence need to be very careful how it's collected and need to be very careful in dealing with the victim. Can you imagine a more traumatizing time in a person's life? Those constitutional rights can make a big difference right then and there. Some courts didn't interpret the rights as attaching immediately. They said, no, we have to wait till there's actually a proceeding in court. So we have that issue yet to get finally resolved. And there are some other issues that that haven't fully been developed by the courts yet and aren't fully consistent with our intent in drafting the legislation. So that needs to play out. And it really is up to lawyers like yourself and the others who are representing the victims to fight hard to ensure that our intent in the federal statute is carried forward in those federal cases. Well, this federal statute also provides a right for the victim to have the proceedings occur without unreasonable delay. So it's not quite as strong as the speedy trial, but the victim still has a right to have the court move this along. And you can imagine why. So that right hasn't been really totally fleshed out either. It's just another example of a right that we have in the federal statute that needs a little bit more bolstering in the federal court for it to become a reality.
What wisdom might you be able to share with those of us working on victims' rights today about how to continue to advance the work?
So the advocates for victims need to continue to be very vigilant and aggressive in making sure that the courts understand what these federal rights are and that they are applied. Advocates of these rights, people who would lobby the legislatures or the federal Congress, for example, they need to continue to be aggressive in their work so that they can continue to advocate the enforcement of these rights in both state and federal court. And I would argue, ultimately, the adoption of a federal constitutional amendment. And that leads me, I guess, to the last group. It's really hard for victims many times to come forth and tell their story. People like Stephanie Roper and Mrs. Campbell, Colleen Campbell, and John Gillis and others were so helpful to us in Congress because they came forward and they told their personal stories about what had happened to them and the members of their family. There's nothing like a personal story like that to let a U.S. Senator know what this is really all about. Hard as it is, need to be willing to come forward and tell their stories. And I know you personally work with them, so the lawyers who are working to represent them need to let them know how important their personal stories can be to actually getting these rights enforced and potentially in the long run to get a federal constitutional amendment.
Before we wrap up, Senator, is there anything else that you want to say about the Federal Crime Victims' Rights Act, the work you did to achieve it, or to those of us doing the work in the field?
Well, just this. It wasn't easy to get done. And frankly, it isn't easy to make sure that it's properly enforced. It's a fight every time. We have to raise the right. Oh, I didn't know that right existed. Well, Judge, it's right here in the statute. Oh, okay. And meanwhile, the prosecutor said, well, we don't really have time for all of that. And advocates like you need to be able to stand up and say, Judge, I have a right under the statute to represent my client, the victim in this case. And here's what the federal statute says they have a right to do here. And to fight those battles in court, those aren't easy, but all of the things which I said need to go forward are important to make sure that the statute that we got passed is not just words on paper, but comes to life every time we have a real trial with real people, because those are the rights that need to be protected.
Well, thank you again for your time today and for all of your work. You made a difference in so many areas over the course of your career, but your impact on victims in this country has been truly astounding. So thank you for that work.
You're very welcome. Carry on.